All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
Good morning again. I give Ms. Adeboyejo the floor.
Thank you, Mr. President, Your Honors. Mr. President, Your Honors, you have already heard my colleagues, Ms. Hola and Ms. Gilg, discuss the general principles on sentencing and touch on mental rehabilitation. I will now address you on the issues of social rehabilitation in the context of the Acholi traditional justice mechanism, and then move on to address you on the family situation of the convicted person. The defense in its sentencing brief implores the chamber to account for the Acholi traditional mechanism of a restorative and retributive justice called matoput in its determination of Mr. Ongwen's sentence. As Your Honors have already heard, the Rome Statute has a comprehensive system for sentencing limited to terms of imprisonment and the imposition of fines. It makes no allowance for traditional justice mechanism, whether of the matoput or any other such traditional justice system. The jurisprudence of this court has established that rehabilitation can be considered by a chamber when considering sentencing, quote, but it should not be given undue weight in the context of the crimes for which the accused person has been convicted, end quote. In particular, the chamber may consider the restoration of peace and reconciliation in affected communities as one factor relevant to sentencing. However, such social rehabilitation goal cannot be the primary purpose for sentencing, particularly in the context of international criminal law. To be clear, the prosecution does not oppose Mr. Ongwen undergoing matoput, if that is what he and the victims wish. But this could and should happen after he serves his sentence or even during the serving of his sentence, if the necessary arrangements can be made. However, these are questions for reparation or the execution of his sentence, and do not bear on the question of whether and how long he should remain in prison. In other words, Your Honors, the Rome Statute makes allowance for such transitional justice measures at a different phase of proceedings, but not for the determination of sentence. As Your Honors are undoubtedly aware, rehabilitation focuses on the need for restoring or reestablishing relationships and socioeconomic status eroded by criminal acts as a means of correcting the wrongdoing and achieving justice for victims and their communities. It focuses on rebuilding relationships and repairing the harm caused by criminal behavior. It may encompass social rehabilitation and reintegration where the convicted person accepts responsibility for his or her misconduct and harm caused to the community, is willing to participate in the restoration of the emotional and material losses that have occurred as a result of the crimes, and is willing to make amends for the harm caused. Rehabilitation in the context of matoput deals primarily with reconciliation and the reconciliation rites, including purification, making confession, compensation, eating together, and then drinking from the same calabash. But these activities have to be preceded by the person admitting that he has done wrong. In the instant case, Mr. Ongwen has not admitted that he has done wrong, and it will be difficult to determine how the reconciliatory nature of the process can be triggered without such an admission. The defense further submitted that this traditional justice mechanism has been discussed and used in Ugandan courts and urged this chamber to do the same. However, the case cited by the defense stands for a different proposition, as we will explain shortly. Contrary to what the defense asserted, the traditional justice mechanism of matoput was not used or applied by the Ugandan court, but was instead rejected by this court. In the case cited, Kanyamunyu Matthew versus Uganda, the applicant had tried to use the matoput mechanism as a basis to request for an adjournment in a murder trial for which he was the defendant. Ruling on the application, the Ugandan court held, and I quote, "In its current form, matoput has no effective system of regulation and review in place. It is shrouded in legal ambiguity, and as a result, its interface with formal criminal justice is opaque." Indeed, the view of the Ugandan court was that considering the limited published data on the traditional justice mechanism, it should play a complementary role to the formal justice system, not serve to displace, undermine, or delay it. Like the Ugandan court, this chamber should find that traditional justice mechanisms, such as matoput, may supplement criminal proceedings, but they should not supplant them. As the court noted, and I quote again, "Noble as the goal of a traditional mechanism for reconciliation and rehabilitation may be, courts have never been equipped nor had sufficient resources to fully achieve the peace-building role. If the court is to aid reconciliation in the manner suggested by the applicant, it is essential that it is well-informed about matoput and understands its processes. Yet, there is very little published data concerning this traditional justice mechanism," end quote. Finally, on this point, Your Honors, although the Ugandan court later reduced the sentence of the accused person, it was on the basis of the plea bargain, which is a formal legal process, rather than as a result of the matoput. I will now move to the issue of the family circumstances of Mr. Ongwen. The defense made submissions on the family circumstances of Mr. Ongwen, arguing that they justify a reduction of sentence. The defense compared Mr. Ongwen's family circumstances to those of Mr. Katanga, asserting that those of Mr. Katanga were considered a mitigation by Trial Chamber 2. The prosecution submits that although Trial Chamber 2 considered the family circumstances of Mr. Katanga when determining his sentence, it held that it could not play a determinant role considering the nature of the crimes for which he was convicted. And so his family circumstances were accorded limited weight. The prosecution submits Mr. Ongwen's family circumstances should not be considered a mitigating factor. In Mr. Ongwen's case, almost all his children are the product of sexual and gender-based crimes committed against young and vulnerable victims. And where children are the victims of crimes, as in this instance, the best interest of the child or children should guide any decision-making process. Such children, as expressly stated in various international human rights instruments, have the right to express their views in matters and proceedings affecting them. Throughout the duration of this trial, Mr. Ongwen filed various applications requesting to add various individuals to his non-privileged telephone contact list, including a request to communicate with his children. The Chamber, in various decisions, ordered the registry to facilitate consultations with the, quote, first wives, unquote, of Mr. Ongwen as the primary caregivers of the children to determine whether they wanted such contact and in what manner the communication will be executed, taking into consideration the protective measures in place for these victims. Some of those victims did not want to have any contact with Mr. Ongwen. This chamber has taken this sensitive approach throughout the duration of this trial, and nothing so far suggests that this approach should change. The prosecution notes with interest the joint filing of the common legal representative for victims and the legal representative for victims on the views and concerns of the victims in the case, and submits that the voices of the, quote, first wives, unquote, and children should be taken into consideration. Mr. Ongwen should not receive a reduced sentence for his family situation if, in fact, they do not want him to be part of their lives. For these and other reasons we have already submitted in our sentencing brief, and which do not need repeating, the prosecution submits that Mr. Ongwen's family circumstances should not be considered a mitigating factor, and even if arguendo they were considered a mitigation, they should be accorded little weight. Your Honors, for the reasons the prosecution has articulated, we recommend that Mr. Ongwen should receive a total sentence of not less than 20 years in prison. Barring any questions from Your Honors, that will be all from the prosecution.
Thank you very much, Ms. Adeboyejo. I think there are no questions. Then we give the floor to Ms. Masida for the common legal representatives of the victims.
Your Honor, one quick procedural note. Ms. Abigail Bridgman has joined the defense in the courtroom.
Yeah, I recognize her, barely, but I do. So welcome after quite a long time in the courtroom. Thank you for informing us. Ms. Masida, you have the floor.
Mr. President, Mr. Manoba will start first and I will conclude. Thank you very much.
Fine with us. Then Mr. Manoba has the floor. We can't hear you at the moment, so we have to solve this first, I think.
Mr. President, can you hear me now?
Yes, now we hear you very well.
Thank you, Mr. President, and Your Honors. Once again, we thank you for the opportunity to address you this time in the submissions on behalf of the victims. Mr. President and Your Honors, Article 77(1)(b) of the Rome Statute sets out that the court may impose a sentence of life imprisonment when justified by the extreme gravity of the crime and the personal circumstances of the accused. The victims are represented by the LRVs in this case overwhelmingly support a sentence of life imprisonment and argue that extreme gravity of the crimes Mr. Ongwen has been convicted for, aggravating circumstances as well as lack of mitigating circumstances warrant the imposition of a life sentence. Mr. President and Your Honors, on the question of extreme gravity and aggravating circumstances, it goes without saying that Mr. Ongwen has been convicted of the most crimes compared to any other accused in the history of this court. What is more salient is the gruesome nature of the crimes committed by Mr. Ongwen, the extensive vulnerability of his victims, and extent of the harm that they had suffered in result of these crimes. The LRVs represent 2,605 victims in the case. Alongside the OPCV, the participating victims in the case amount to just over 4,040 victims. By conservative estimates, these victims represent merely 10% of the total number of victims that were the subject of the attacks on Pajule, Odek, Lukodi, and Abok, and for which Mr. Ongwen has been found guilty by Your Honors. These victims, some voluntarily and others by government directive, had been seeking refuge from the LRA in highly overcrowded IDP camps. The court has heard how within those camps the victims were forced to endure appalling humanitarian conditions from food, clothing, health, and sanitation. By all accounts, the victims had been rendered destitute and dependent by circumstances beyond their control as a result of the atrocities of the LRA. These camps, Your Honors, were like gulags, with the minor luxury of not having to engage in forced labor. In spite living in conditions that many following these proceedings can hardly conceive enduring, the victims strove to hold their families and their dignity together. That was until the night of the respective attacks. Your Honors, these attacks took anywhere between 1 to 6 hours. 1 to 6 hours that led to irrevocable devastation, between 1 to 6 devastation for the defenseless victims of Mr. Ongwen's crimes. Mr. President and Your Honors, as evidenced by the LRV expert witness V0001 in her evidence and her report, UGA V40/0001 to 0010, not only individual victims, but entire communities continue to suffer from the consequences of these crimes up until today. In the few hours, Your Honors, at least 2 out of 5 victims represented by the LRV had lost a family member or a close relative. 3 out of 4 had their property looted and or destroyed by malicious arson. 3 out of 10 would suffer injuries, and at least 90 individuals would report experiencing incidences of rape and sexual violence. Yet, The victims participating in this case represent a conservative estimate of nearly 10% of the entire body of victims affected by the crimes for which Mr. Ongwen is convicted. Compounding the vulnerability of the victims and the scale of the crimes was the manner in which they were conducted. The murders were shatteringly obscene. Some of the victims had to watch their young children being thrown into burning huts, being placed into gunny bags and stomped to death, or being flung headfirst against tree trunks to quell their frightened cries. Some of the victims were fortunate to escape, only to find the remains of their loved ones moldering in the ashes of burnt-out huts, chopped to pieces, stabbed or shot, with their remains being consumed, in some cases, by animals. And for what, Your Honors? What could possibly have been the cause for this incredibly cruel assault? The mere misfortune of being perceived to have failed to support the LRA by seeking refuge in camps. Mr. Ongwen and the LRA were determined to teach the victims a lesson for not being eager to sacrifice their sons, their daughters, and the fruits of their labor to a war that they had not supported, a war that had brought them nothing but dread and despair. Your Honors, the effects of that lesson continue to haunt the victims of their communities to this day. Perhaps a few examples could shed some light on the impact of this lesson in quotes. Victim A/00048/16, who was 65 years old at the time of the attack, was caught by the rebels while attempting to escape and beaten until he had been rendered unconscious. His son was abducted and has never returned. He developed a urinary tract infection from being kicked repeatedly to the lower abdomen and has been unable to stand upright or move without pain since the attack. How about victim A/06-730/15, whose son was shot dead as he watched? He was thereafter viciously beaten. The victim later suffered a stroke as a result of the injuries caused by the beating, which has left him partially paralyzed. These vicious assaults did not discriminate between the elderly or the young, male or female. Your Honors, victim A/06764/15 was beaten, stabbed to the head, arms and waist, and shot in the ankle of the left leg. The victim has since been rendered physically weak and unable to walk without crutches. He was 70 years old at the time of the attack. Another victim, A/06722/15, was 76 years old at the time of the attack. He was abducted and beaten again viciously to his body and head. The victim lost his eyesight due to the trauma to the head. Similarly, victim A/06685/15 was 4 years old at the time of the attack on a Bok IDP camp. She was stabbed in the head and had rebels stomp on her waist, dislocating bones therein. She has since been mentally unstable owing to the stab wound to the head. Your Honors, if we had a couple of hours, the LRV could provide example after example, description after another of the savage, senseless, and unprovoked attacks on the residents of the 4 IDP camps, charged IDP locations. All inconceivably cruel and all completely unnecessary without any justification. The unarmed and destitute victims posed no threat to the rebels. To the contrary, they were completely defenseless after the rebels had strategically scattered the few PDF soldiers that had been their last line of protection. Yet, they were met with ravenous and implacable cruelty. The chamber, the parties, and the victims all heard the voice of Mr. Ongwen proudly boast of the devastation he had caused and the lives he had snuffed out after each attack. Lives such as those of the wife and son of victim A/06731/15, who were killed as he helplessly watched, or the lives of the family members of victim A/06423/15, whose father, mother, and grandparents all met their death on the same day, leaving her an orphan at just 4 years of age. The Chamber honorably gave recognition to the lives that were lost in its oral and written verdict. The Chamber also noted how callously Mr. Ongwen had reported about the lives he had ended shortly thereafter. Mr. President and Your Honors, compounding the gruesome death, the vicious physical assaults, and the wanton destruction of property were the incidences of abduction followed by sexual violence that befell a number of victims. And I would like to highlight some of these victims. Victim A/00260/16 was found in her house and gang raped by the rebels. Afterwards, they tied her up and tried to force her brother to rape her. When he declined, he was chopped to the head and killed. She was abducted and taken into captivity, but was fortunate to escape after 5 days. She returned home to find that her husband had also been killed on the day of the attack, and that her daughter also had been abducted. The victim has not seen her daughter since. Victim A/01996 was caught while attempting to escape the attack and abducted. When they reached a stop, she was gang raped by 4 rebels, who thereafter proceeded to viciously insert sticks into her private parts. The rebels left her to die after she began to bleed profusely. She was fortunate to be found by UPDF soldiers who took her to hospital. She later discovered that her bladder had erupted as a result of the gang rape, and to this day she struggles to contain her urine. These, Your Honors, are but a few of the grievous accounts of sexual violence, and the LRVs have left out the more gruesome accounts. Beyond the attacks on the IDP camps were victims that were abducted and given as forced wives, for whom the instances of rape would persist until their escape or in some sad cases until their hopeless submission into the role, as we have heard from the submissions of the prosecution. But still, Your Honors, I would like to highlight examples of our clients who suffered similar experiences. Victim A /06797/15 was found in her hut and abducted with her 8-year-old daughter. While in captivity, she watched as her daughter was handed to one of the rebels as a wife and was herself given as a wife to another rebel who proceeded to rape her almost every day of the 2 weeks she was in captivity. Even at the point when her uterus protruded from her body, the rebel would not restrain himself from raping her. She was fortunate to escape, but she has never seen her daughter since. The injuries caused by the multiple rapes have rendered her barren, a further indignity that she must endure for the rest of her life. Mr. President and Your Honors, the LRVs note that the abductions and the distribution of young girls as domestic slaves, referred to as ting-tings or forced wives, for which Mr. Ongwen has been found guilty, occurred over a period of 3 years. Victim A/01288/16 was 8 years old when she was abducted during the attack on Odek IDP camp. From the second day of her captivity, she was raped by the rebels as she would move in the bush. She was forced to participate in killings and in desecration of dead bodies. Later, she was given as a wife to a rebel that she estimates was about 40 years old, who proceeded to rape her for at least the 2 years that she stayed in captivity until her escape. She returned home to discover that her father and mother had been shot dead on the same night of the attack. Similar to the abduction and distribution of young women and girls, Mr. Ongwen oversaw the abduction and conscription of children into the LRA to take part in hostilities. The conscription of freshly abducted children involved inhuman initiation processes that were geared to bring the victim into submission to his or her then fate. I highlight an example here. Victim A/07089/15 was 13 years old when he was abducted in 2002. At his initiation, his back was marked with the sign of a cross using a machete that had been heated over a flame. At times, he was ordered to participate in the killing of older people by beating them to death. The victim remained in captivity for 2 years until he managed to devise a means to escape. Your Honors, the attacks on the victims' communities at their most vulnerable were particularly diabolical and sought to achieve total devastation. The attacks intentionally set out to violate the victim's physical integrity for their ostensible refusal to support the LRA. The attacks were intended to take away their material provision by not only looting those items the victims depended on for their daily survival, but by also destroying everything that could not be carried away. The attacks intentionally sought to take away the victim's sense of safety and security, targeting both the armed personnel in the army barracks and the adult males in the camps for destruction. The attacks were geared towards compromising the integrity of the social structures, with the adults being killed or severely brutalized, and the children being abducted to serve the LRA. Mr. Ongwen planned and ordered this devastation. Mr. Ongwen was successful in achieving this devastation. Mr. Ongwen, Your Honors, spoke proudly of this devastation. I will now address some of the issues, Your Honors, concerning the personal circumstances of Mr. Ongwen and the lack of mitigating circumstances. Your Honors, to date, Mr. Ongwen has shown little remorse for the attacks and the grievous crimes committed against his victims. To the contrary, Mr. Ongwen attempted to deny being responsible for the attacks. What is particularly troubling for the victims is how Mr. Ongwen has sought to fashion himself as the actual victim of the crimes for which he has been brought to justice. The defense, in their sentencing brief, has sought to accomplish this first by appealing to Mr. Ongwen's abduction at a young age, and additionally arguing that through indoctrination and supposed brainwashing, Mr. Ongwen, and I quote, did not possess a mind of his own to lawfully comprehend. This is paragraph 15 of the defense brief, Your Honors. However, this argument of the defense completely ignores the evidence on the record of the case and the findings of the judgment concerning defenses raised by Mr. Ongwen, both the mental disease or defect and duress arguments. Furthermore, the submissions of the defense are self-contradictory. On the one hand, the defense claimed that, and I quote, Mr. Ongwen witnessed Joseph Kony preach and predict the future, further entrenching Mr. Ongwen and those around him into the belief that Joseph Kony was omnipresent, omnipotent, that their escape plans would be known and they would suffer dire consequences for trying to escape. This is paragraph 83 of the defense brief. In the same breath, while attempting to support the claim of Mr. Ongwen's supposed good character, the defense posits that Mr. Ongwen kept secret the escape plans of one of his comrades, who successfully escaped in spite of the supposed omniscience of Joseph Kony. And I refer to paragraph 153 of the defense filing. The defense also assert, and I quote, had Mr. Ongwen been older and better educated, his life may have turned out differently. He may have stood up to Joseph Kony like Otila Gony, Okello-Chan Adonga, or Oti Vincent. He may have tried to escape and succeed. End of quotes. And I'm making reference to paragraph 123 of the defense brief. And at the same time, Your Honors, the defense point to two instances where Mr. Ongwen successfully intervened to reverse death sentences allegedly set by Joseph Kony in respect of P205 and P231. In one of these instances, Your Honors, the witness supposedly saw Mr. Ongwen successfully arguing with Joseph Kony to rescind a death sentence which was substituted for several lashes. This is paragraph 155 of the defense brief. Your Honors, these examples show how selective Mr. Ongwen's supposed good character was. Sadly, the men, women, and children that were bludgeoned to death shortly after their abduction from the attacks on the IDP camps saw the limits of Mr. Ongwen's compassions, as did the young girls taken and given as forced wives and serially raped for their entire duration in the LRA. The children Mr. Ongwen abducted saw nothing of his purported compassion. Such was their experience of Mr. Ongwen's compassion that they opted to risk death and escape than spend more time within Mr. Ongwen's unit. The implication of the defense submissions is that far from being a helpless, unwilling instrument under Kony's full control, Mr. Ongwen would on occasion choose to exercise kindness and compassion towards his fellows. Mr. Ongwen could have chosen to show compassion to the victims of the IDP camp attacks. He could have shown compassion to the abductees prior to having them subjected to sexual violence as forced wives or prior to having them conscripted for use as child soldiers. Instead, Mr. Ongwen chose extreme cruelty to these victims and exercised callous indifference to their suffering. For the victims, the attempt to paint Mr. Ongwen solely as the victim is just another display of this indifference. Since the judgment, which was greeted quite fondly by the victims represented by the LRVs, the victims have witnessed one person after another attempt to mollify the gravity of Mr. Ongwen's crimes by emphasizing his abduction his abduction and previous status as a child soldier, to the complete disregard of the actual victims of his crimes. Your Honors, it may be helpful to note that Mr. Ongwen was not just an ordinary LRA fighter, but a high-ranking member of the LRA. The victims that we represent are surprised to find that even the prosecution have succumbed to this mawkish notion of Mr. Ongwen's abduction as suitable mitigation for the crimes for which he has been convicted, in the face of a complete lack of acknowledgement or expression of remorse for his crimes, as the prosecution themselves have acknowledged in their submissions. Mr. Al-Hassan has in this very court been sentenced to 10 years imprisonment for acts that involved the destruction of historical sites, acts for which Mr. Hassan admitted responsibility. Yet, the prosecution in this case recommends just 10 more years for acts that violated the sexual integrity, liberty, life, and physical well-being of thousands of defenseless victims. And while the destruction of a religious World Heritage Site is indeed grave, the crimes committed by Mr. Ongwen are profoundly more grievous given their nature and the number of people affected by them, acts for which Mr. Ongwen has neither acquiesced nor shown any remorse. Your Honors, to appreciate the absurdity of this approach, perhaps it may help to change the context. If Mr. Ongwen from Uganda had instead been a Mr. X who, from a young age, had been forced to undergo a strict religious and armed training within a warring Islamic fundamentalist organization, and on achieving adulthood, the Mr. X was given charge of a company of young soldiers that proceeded to murder, torture, rape, and pillage civilian communities in the name of a religious cause or a divine purpose. Would the experience of his youth be entertained or counted to outweigh the gravity, magnitude, extent, and impact of crimes he had committed as an adult? The sentence proposed by the OTP undermines the solid conviction delivered by this chamber and the function of retribution and deterrence that punishment has in the Rome Statute. The sentenced, we submit, must be adequate to the number and gravity of the crimes for which Mr. Ongwen has been convicted, and also in the context of the court's sentencing practice to date. Otherwise, the court will send a message to present and future perpetrators that no matter how grave their crimes are, how many people and communities they violated, they can expect a lenient punishment if an appeal can be made to their peculiar privations of their youth. Your Honors, I would like to now address the last part of our submission, which is on the relevance of the Matoput ritual that has been addressed by the defense in their brief. The defense attempts to make the case that the availability of Matoput traditional Acholi dispute resolution mechanism should at least partly substitute a court-ordered imprisonment sentence for 62 counts of war crimes and crimes against humanity. However, the defense's request in this regard is manifestly detached from the reality of this case, primarily the number and extreme gravity of the crimes for which Mr. Ongwen has been convicted. The defense seems to forget that the communities harmed as a result of Mr. Ongwen's actions are not limited to the Acholi community, but rather the victim communities include the Langi and the Teso communities. Therefore, any traditional Acholi reconciliatory mechanism are of limited application in this case, as they do not extend to all affected communities. As regards statements provided before this chamber, among others by the representatives of the Kerkwaro Acholi, victims are shocked by their calls for the substitution of Dominic Ongwen's judicial sentence with the Matoput cultural process. Our clients find it troubling that institutions like the Kerkwaro Acholi make such submission without seeking views from victims of his crimes on the matter. The victims are adamant of their disapproval of the suggested Matoput process. And Your Honors, I would like to briefly highlight some of the views expressed on this matter by our clients. Victim A/05601/15 noted, and I quote, "Matoput happens only when there is acceptance. If I, as the victim, refuses, it cannot be conducted. I want him imprisoned so that he suffers like the rest of us. We do not want Matoput. Victim A/05-207/15 noted that Matoput cannot be utilized for the crimes that Dominic Ongwen committed, including the abuse of young girls and women and other atrocious acts. She went on to state, if it was a single crime, we would resort to possible use of Matoput. But because of the nature of the crimes Mr. Ongwen committed, we cannot consider the use of Matoput. Victim A/05270/15, who sits on the Kerkwaro Acholi Council, also noted as follows. Matoput is very important, but if there is no admission, then Matoput cannot happen. Matoput happens when the two clans convene and admit that they are ready to engage in this ritual of Matoput. And it happens when they have offered compensation and they meet the requirement But for Ongwen's case, it is hard. Karl Kwaro shouldn't come in. I am a member of the council, but they shouldn't barge in. Did they consult the victims? We are harmed, and they weren't here. Will they pay? Each of the 4 locations has its own clans, so they shouldn't impose themselves. They should let him remain there. What will Lamogi do for us? I have rejected it, and I am not happy with their actions, along with religious leaders. They shouldn't intrude. Did their children die? Were their property destroyed? End of quote. Your Honors, contrary to the cultural dispute resolution, victims overwhelmingly support a sentence of life imprisonment. These victims in no way share the sentimental affections for Mr. Ongwen's status as a former child soldier. Victim A/06667/15 lost her grandmother, who was burnt to death in her hut during the attack, and her stepson was placed in a sack and stomped by the rebels to death. Her view is clear, and I quote, "What Dominic Ongwen did to us here, the punishment he deserves is death, but if that is not an option, then he should not be allowed to return, because our loved ones are in the ground and we cannot bear the sight of him." Another victim, A/06308/15, explained this sentiment as follows, and I quote, "There is anger which is leading people to recommend life. People are angry because, 1, he says he was a child, but when he attacked, he was an adult who should have had mercy because others showed mercy. He had no mercy and the ways he killed. He should have had mercy as a human. 2, they abused children who were underage, while others were harmed as they were running. 3, he had no mercy, even though now he's asking to be shown mercy. He should have asked for forgiveness then, not now. If he were my own child, I would say he should die for his crimes, so that the people who suffered can get justice. Another victim, A/06134/15, was followed to the place where she had sought to hide from the attack and raped in front of her child. Moreover, she had one uncle shot dead during the attack and another abducted and killed in captivity. She observed as follows, and I quote, "Because of what I experienced, that painfully affected me. I think he should be imprisoned for life and he shouldn't get to see the faces of his children. I say this because he caused the loss of so many people's lives, and children remained without knowing the faces of their fathers and mothers. His children should also experience the same. His actions led to death in Lukodi that was painful, and the running he made us do caused injuries to people." And then he denied the charges. If he had admitted earlier, we would have forgiven, but he kept denying, so he should be imprisoned for life. Your Honors, one last highlight here is victim A/05508/15 escaped the attack only to return and find that her husband, her brother-in-law, her sister-in-law, and their children had been burnt to death. Placing aside her affliction at the hands of Mr. Ongwen, he rationally pointed out the broader impact of the crimes on the community. She rationally pointed out the broader impact of the crimes on the community when she noted that, and I quote, "Mr. Ngwen's crimes includes recruitment. He abducted children and taught them to kill. He abducted girls and made them become his wives. Both these categories of former abductees are dealing with mental illness. In the past, when someone killed, compensation needed to be done. If someone hurts you badly, they have to pay compensation to soothe the victims. The children who were abducted return to find the parents are killed, and that causes more trauma. When they return with children to find their parents gone, it increases mental health problems." She further emphasized, end of quote, and she further emphasized that, and I quote, that the crimes are too big to forgive, so he should be imprisoned for life. These children's lives is not well. Their minds are confused. They have no education. They consume alcohol, and then they start to remember their experiences and they become aggressive. They don't speak English and get offended when spoken to. It is very common here, end of quote. With more time, Your Honors, the LRVs could provide similar views after view of the victims expressing their preferences for a life sentence. And even among the few that do not seek a life sentence, significantly, long sentences are preferred. As a way of example, victim A/05295/15 is 82 years old. He was 65 years old at the time of the attack when his elderly father was stabbed to the belly and killed. He observes that, and I quote, for one convicted over 60 counts of crime, it sounds inconceivable that he would be given a few years in prison. He should be imprisoned for about 40 to 60 years. He should stay there for long so that people my age die before they see him. We can't look at him with good intentions because he reminds us of the harm we suffered. If he stays there, maybe by the time he returns, the children who remain won't remember what happened. Similarly, victim A/05385/15 was of the view that, and I quote, for what Ongwen did gravely against people, like killing, looting, sexual violence against women, and more, I would suggest that the ICC considers sentencing him to serve a year for each count of crime. The 61 counts should be equivalent to the number of years to be served. If not, then he should either be killed, like someone earlier said, or imprisoned for life. I recommend 61 years because of the nature of the crimes that he committed. The punishment should be proportionate to the acts he committed. He was a big person and he abducted young girls whom he abused and spoiled their ability to have children, end of quote. This victim's father was shot and burned to death in the attack. His two sons were also murdered on that day, and his mother would later succumb to a gunshot wound to the leg sustained during the attack. In conclusion, Your Honors, the victims would like to emphasize that Mr. Ongwen is the perpetrator and not the victim in these proceedings. And while his abduction was entirely unfortunate, Mr. Ongwen, like other victims in the case, had a choice to either remain in captivity or seek to escape the LRA. For a large number of our clients, there will never be a day when they are not afflicted by the harm he caused. For those who lost their loved ones, there will never be a day when those loved ones will return. For those who were raped, there will never be a day when they will be free from its physical, social, and psychological indignities. Those who are dead will never again see or aid their loved ones. Those who lost their limbs or were grievously injured will never be whole again. The victims that were rendered impoverished and destitute after the looting and destruction of their property continue to struggle to restart their livelihoods. Those who dropped out of school can only hope to find such unskilled labor as would enable them to successfully educate their children and break the cycle of poverty and ignorance, their dreams of a better life having been dashed from a young age, all at the hands of Mr. Ongwen. The victims have found great value in having their experiences accurately reflected in the truth-seeking process. The LRV are pleased to report that the victims have been greatly satisfied by the conduct of the judicial proceedings and by the well-reasoned and satisfactory judgment on the crimes for which Mr. Ongwen stands convicted. The victims have thought a great deal of what their hopes and aspirations are for a just outcome of the trial proceedings. They have been waiting for this moment for over 15 years. They now ask Your Honors to complete the delivery of justice in this case, to give Mr. Ongwen the just penalty deserved for his crimes, the maximum sentence that reflects the full extent of gravity, and impact of his crimes not only on the lives of the individual victims, but to the physical, psychological, material, and social well-being of their communities, and to the prospects of life and the futures of their generation. The victims, Your Honors, overwhelmingly support a sentence of life imprisonment for Mr. Ongwen for the ruinous crimes visited upon them, both as individuals and as a community. This ends the submissions of the legal representatives for victims on sentencing. Thank you, Mr. President, and thank you, Your Honors.
Thank you, Mr. Manoba. Ms. Masida, do you already know how long it will take you? Because we are some 20 minutes before a lunch break.
I would say a maximum of 30-35 minutes. I will not use 45, but 35.
Then I think you can start, I would suggest, yeah.
Mr. President, Your Honors, victims wish first to convey to the Chamber their appreciation for the recognition of their victimization and the extent of their sufferings, notably during the reading of a summary of the judgment on the 4th of February this year. For them, the necessary corollary of recognition of Mr. Ongwen's guilty is an exemplary sentence which will fully recognize the extreme gravity of the crimes committed and the significant role played by the convicted person in the commission of said crimes. A sentence which will recognize the large-scale, protracted in time, and serious violations by Mr. Ongwen of the fundamental human rights of his victims. Victims' voices have to be listened to and duly taken into account at this crucial stage of the proceedings. In fact, many studies show the increase in victims' empowerment when involved in the sentencing process and how, when victims' voices are heard and duly comprised in the sentence decided by the judges, it plays a major role in their path of healing and reconstruction, as well as on the possible reconciliation within affected communities. In recalling entirely the written submission jointly filed with my esteemed colleague representing the other group of victims in these proceedings, I will today focus only on some aspect of the prosecution's and defense written submission on sentencing which have a clear, specific impact on the interest of the victims I represent. Starting with the prosecution position. The prosecution recognized the extremely grave nature of the crimes for which Mr. Ongwen has been convicted, as well as the harm he inflicted on thousands of victims, but recommends to diminish the sentence to be eventually imposed by 1/3. To reach this conclusion, the prosecution indicates that the personal, social, and economic circumstances of Mr. Ongwen warrant not only to discharge him of the highest sentence foreseen in the legal text of the court, life imprisonment, but also should lead the chamber to substantially reduce his sentence. This conclusion appears to the victims inconsistent with the recognized extreme gravity, or to quote the prosecution this morning, exceedingly grave crimes committed. The prosecution itself recalled inter alia in paragraph 15 of its submission the crimes and the gravity of the crimes as follows, I quote, "He, Mr. Ongwen, raped, tortured, enslaved, sexually enslaved, forcibly married, and forcibly impregnated several women and girls. He was a key participant in the crimes, planning or commanding the attacks, ordering abductions and other crimes, and perpetuating and enforcing the LRA's large-scale and systematic sexual and gender-based crimes and conscription and use of child soldiers. End of quote. The personal circumstances to which the prosecution refers to request not more than 20 years of imprisonment is the fact that Mr. Ongwen was abducted at the age of 9, had a very difficult childhood and adolescence in the LRA. Your Honors, in the views of the victims, these circumstances cannot balance, let alone diminish the fact that subsequent to his abduction, Mr. Ongwen chose to remain in the LRA, rose through its ranks till reaching a senior status, which, to use the words of the prosecution, afforded him prestige, power, and relative comfort, and committed the 62 crimes mentioned in the judgment against thousands of innocent and defenseless victims. With all due respect, the sentence requested by the prosecution in this case is at the minimum inconsistent with the findings in the judgment and even with prior practice of the prosecution before this court on sentencing. In cases involving much less charges for crimes committed in a narrower period of time, and in which the extent of a victimization is not comparable at all to the one in this case, the prosecution asked higher sentences compared to the one it requests in the present case. In the Lubanga case, the prosecution asked 30 years of imprisonment. In the Bemba case, not less than 25 years of imprisonment. Victims do not intend to minimize or deny the fact that Mr. Ongwen was abducted at a young age and was faced with many sufferings himself. However, they do not see this part of his history as a reason justifying the path he chose to take in the LRA and warranting any reduction of his sentence. In the victim views, Mr. Ongwen chose to commit the crimes, committed them against particularly defenseless and vulnerable victims, aging from few months, the babies thrown in the bush, for instance, to the oldest age reached by elderly members of the community, thrown in houses and burned alive or stabbed to death. Victimized children instead of protecting them. Sexually tortured and enslaved girls and women for years. Deprived families from their life, tearing them apart, decimating them, and leaving them with nothing to eventually rebuild even a semblance of life. The judgment unequivocally recognized Mr. Ongwen's status in the LRA hierarchy, his power and authority, his loyalty to Joseph Kohn, and the fact that he fully shared the purpose of the LRA and fully contributed to it by executing and ordering the commission of the crimes. Contrary to the attempts by the defense to portray the good character of Mr. Ongwen by indicating that he saved lives while in the LRA and showed kindness and mercy to some people, the judgment recognized that he killed and harmed 1,000 others, and that he did so with a level of incomparable cruelty. The same goes for the fact that he released a few abducted people while he kept under his custody hundreds of others, among whom wounded, pregnant women with babies, and young children. Therefore, Your Honors, victims cannot share the position expressed by the prosecution that it is unlikely that Mr. Ongwen would have committed the crimes he did in 2002, 2005, had he not been abducted on his way to school in 1987, and that the sentence should not ignore Mr. Ongwen's experience as side shoulder in the LRA. Victims are, on the contrary, of the opinion that Mr. Ongwen would not have committed the crimes he did in 2002-2005 had he escaped from the LRA or chosen to behave in a different manner while in a position of power in the LRA. Mr. Ongwen chose not to leave the LRA when afforded the opportunity to escape and reunite with his community, and refused to do so by continuing to stay in the rebel group and commit the crimes he is now convicted for. For these reasons, victims are of the view that Mr. Ongwen's prior history in the LRA cannot be a factor sufficient to diminish his sentence. Turning to defense submissions. The defense submissions are entirely centered on the alleged specific circumstances of Mr. Ongwen, which should be taken into account by the Chamber in deciding on the appropriate sentence. Some of these circumstances constitute a mere repetition of arguments already submitted during trial and are adequately considered in the judgment, such as the fact that Mr. Ongwen would have been indoctrinated and brainwashed to a point that, and I quote again as my learned colleague from paragraph 15 of the defense submissions, he did not possess a mind of his own to lawfully comprehend, end of quote. This assertion, while lengthily argued and carefully assessed during the trial, was proven incorrect on the basis of credible evidence presented at trial. Therefore, it cannot reasonably inform the sentencing decision. The defense line of arguments also insists on the fact that Mr. Ongwen was a child soldier and is allegedly a mental disabled person. To use the words of the defense in paragraph 13 and 38 of its submission, and I quote, "He was stolen from his family at the age of 9 and forced to live, grow, and work in a horrible cold, having permanent physical damage and continuing psychological trauma. Therefore, it would be a travesty of justice that would reverberate throughout the annals of history if this child soldier, a mentally disabled person, is made an example by the international community." End of quote. Your Honors, Mr. Ongwen is not a child soldier and was not convicted for crimes he might have committed as a child soldier. It was also not established before the Chamber that Mr. Ongwen is a mentally disabled person, and in this respect, we fully share the prosecution submission presented this morning. Mr. Ongwen is a man who was faced with a very difficult childhood, part of which was in the LRA, and who, when becoming an adult, decided in full conscience and following his free will to commit the most atrocious crimes in the most unspeakable manner, for which he has been convicted by this chamber. Therefore, and again also argued by the prosecution this morning, all defense arguments related to duress and the alleged diminished mental capacity of the convicted person should not be considered by the chamber when deciding on the sentence. The same applies to the argument that Mr. Ongwen could not escape. This factor has no relevance for sentencing purposes, and eventually it is a factor running against the personal circumstances pleaded by the defense, because countless of other abductees did choose and manage to escape from the LRA. As noted already in our written submissions, in accordance with the legal framework of a court and its relevant practice, the determination and imposition of a sentence shall be based on the principles of retribution and deterrence. In this regard, victims disagree with the defense argument suggesting that a long sentence against Mr. Ongwen would not discourage others from committing similar crimes in the future, but rather encourage former child soldiers to remain in the rebel groups or hide for fear of receiving long prison sentences for their actions. To the contrary, victims submit that because of the extreme gravity of the crimes, the sentence has to be exemplary in order to discourage individuals to commit similar crimes as the one for which the accused was convicted. An exemplary sentence will have a deterrence effect because it will show unequivocally that someone was abducted at a young age, became a child soldier, rose in ranks, becoming a commander, chose to commit through his own initiative the most horrifying crimes, refusing to surrender when given the chance to, and finally recognized guilty of the most serious offenses against mankind in the terms the judgment does, will face the right consequences of his behavior in a court of law. Above all, it will show that justice for victims exists and that impunity will never prevail. During the recent consultations held with victims, one of them stated that, and I quote, "A longer sentence would act as a deterrent and prevent those who have the intention of committing similar crimes to realize that there is punishment as a consequence," end of quote. This view was reiterated by other victims who highlighted that a long sentence would deter others from forming or joining rebel groups, and, I quote again, "His punishment should be seen to be a punishment for all the crimes he committed," end of quote. Another victim stated clearly, quote, "The crimes Dominic Ongwen committed are painful, so he deserves life imprisonment. If he's given a lighter sentence, it will encourage other people to commit crimes. Even if he was my brother, I cannot change my mind. It will encourage people to commit crime," end of quote. Victims also disagree with the suggestion to surrender Mr. Ongwen to the Acholi traditional justice system. Beside the fact that that suggestion is not an option in the ICC legal framework, victims wish and ask, as part of the acknowledgement of their victimization, that this chamber imposes a sentence which reflects the gravity of the crimes for which Mr. Ongwen was convicted, but also the sufferings they endure and continue to sustain as a result of the commission of his crimes. In this regard, victims emphasize once more that any traditional ceremonies and rehabilitation rituals could only be followed separately from and eventually in addition to the sentencing proceedings. More adequately between Mr. Ongwen's clan and the victim's clan and communities, rather than between Mr. Ongwen himself and the thousands of victims individually concerned by the crimes he committed. Such rituals, in the victim's views, should eventually complement reparation measures awarded by the court and are not seen by the victims as incompatible with a sentence of life imprisonment. Because victims attach great importance to the judicial process, they do not share the defense attempt through witnesses from the Kirkwara Acholi to let the chamber and everyone following these proceedings believe that there would only be one culturally appropriate way to respond to the situation of Mr. Ongwen, both for his rehabilitation and for the communities affected by his crime, namely by surrendering him to them in lieu of any sentence of imprisonment. The thousands of victims consulted in the last month for the purpose of this sentencing hearing seem to approach the situation quite differently and to see other ways to move forward that would be culturally appropriate for them, their families, and their community. Referring to their tradition and the need for reconciliation, victims insisted on two key aspects. First, that the ceremonies could and should only happen after they have benefit from reparation and not as a part of a sentence. Second, that said ceremonies could only happen if Mr. Ongwen would sincerely ask for their forgiveness. The fact that the defense already announced its intention to appeal the judgment in itself represents an affront for them and a contradiction with any future expression of sincere remorse. The same goes, Your Honor, with the most recent defense assertion in its submission on sentencing that it does not concede Mr. Ongwen's guilt. In this regard, I wish to recall the statement made by Uganda cultural, religious, community, and civil society leaders attending the opening of the trial of Mr. Ongwen at the seat of the court back in December 2016, and I quote, "Today, the case of Dominic Ongwen remains very important to us because it is a milestone in defining one way in the attempt to secure justice and accountability for the people of Northern Uganda, and ultimately to help people reconcile with their past and move towards peace. As leaders and representatives of various groups and interests in the Acholi region, we note that various grave crimes were committed in Northern Uganda during the time the LRA was active. The nature of the crimes committed violated traditional, Uganda, and international law. and therefore warranted action against perpetrators in terms of securing justice for the victims and holding the perpetrators accountable. End of quote. I'm turning to the very last part of my presentation, Your Honor. It will take, I think, 5 minutes. Specifically on the quantification of the sentence proposed by the defense. And again, we share the arguments proposed by the prosecutor this morning. Article 78(3) of the statute and Rule 145 of the Rules of Procedure and Evidence clearly prescribe the determination of a sentence by a chamber for each crime committed and not per acts. Finally, the defense requests that the time spent by Mr. Ongwen in the LRA be deducted from his sentence is equally deprived of any legal basis. Indeed, the applicable provisions are clear in indicating that only the time spent in detention pursuant to a warrant of arrest issued by this court may be deducted for that purpose. Your Honors, victims practically unanimously expressed their strong wish that Mr. Ongwen be imprisoned for the rest of his life. Many of them fear the day Mr. Ongwen might be allowed to come back to Uganda. In accordance with Article 78(1) of the statute, the totality of the sentence must be proportionate and reflect the culpability of the convicted person and should be tailored to the gravity of the crimes. Gravity is the principal consideration in the imposition of a sentence. In the present case, the nature of the crimes, the particular circumstances of the conduct constituting elements of the mode of liability recognized by the Chamber, and the factors under Rule 145(1)(c) of the Rules relating to the elements of the offense and modes of liability are all elements militating for the extremely grave nature of the crimes committed. Moreover, in the victim views, some factors should also be considered as aggravating circumstances. 1, the extreme cruelty and brutality in the commission of the crimes. 2, the particular defenselessness of the victims. 3, the high number of victims. And 4, the abuse of power by and or the official capacity of Mr. Ongwen. In light of the evidence presented at trial and the findings of the Chamber in its judgment, no mitigating circumstance apply in the present case. In particular, none of the mitigating circumstances contemplated by the defense can be considered as established: duress, mental illness, and therefore none of them would warrant to reduce the length of a sentence that would be appropriate on the basis of the extreme gravity of the crimes for which Mr. Ongwen was convicted. And finally, Your Honor, nothing in Mr. Ongwen's individual circumstances appear to reduce the need for the highest sentence possible. Victim request that Mr. Ongwen be sentenced to life imprisonment. Such a sentence appears to be the only appropriate punishment in light of the extreme gravity of the crimes, which were marked by their infamous cruelty and inhumaneness, causing immeasurable harms to the victims, their families, and their communities. Life imprisonment is the only adequate response to the incurable pain inflicted to more than 4,065 victims who still face, more than 15 years after the events, unprecedented challenges in recovering from the harm they suffered from as a result of the crimes Mr. Ongwen committed. Life imprisonment is the only adequate response to the memory of thousands of victims who could not see justice done in a court of law. Your Honors, Mr. Ongwen was not convicted for ordinary crimes, but for the most serious crimes of international concern and extraordinary crimes as the ones for which he was declared guilty call for an extraordinary sentence. This concludes, Your Honors, my submissions on behalf of victims we represent. Thank you very much.
Thank you, Mr. Masida. This would be now the time for a lunch break, after which we would hear the oral submissions by the defense on behalf of the convicted persons. I have already said there is a total of 3 hours. Can you already envisage how much time it will take you for your submissions? Mr. Ayena, please.
Thank you very much, Mr. President, and Your Honors. Unfortunately, we have allotted some time to the convict to make a statement. And because of his peculiar arrangement with the prison people, he had not carried his material for this afternoon. So since we wanted him to start, that was the arrangement. We are making a request that we continue tomorrow.
Oh, of course, this is fine with the chamber. I assume that's not a problem. So you want to start with Mr. Ongwen speaking tomorrow morning?
Yes, Your
and you would, or Mr. Ophoff, whoever would come afterwards.
Yes, please.
Yeah. It is fine with the chamber if you don't overstep the 3 hours of allotted time.
We
Yeah.
promise.
Yeah. Okay, good.
We promise.
Then we finish the hearing for today and meet again tomorrow at 9:30.
All rise. Veuillez vous lever.